Ma'am, the screen sharing option is disabled.
No, you can do that. We have enabled it.
Sir, it's
Okay,
not
okay.
appearing.
Let me see. Let me see. Just a second. Right. Just check right now.
Okay. Uh, is it visible, sir?
Yes, ma'am, it is completely visible. Please go for it. Make sure that your time limit is 7 minutes.
Okay, ma'am. Yeah.
Please continue.
Good afternoon to one and all present here. My topic, the paper which I'm going to present today, is with reference to GST and fiscal federalism, constitutional challenges to state autonomy in India. So the research problem for my paper is that has GST, while successfully creating a unified national market, fundamentally undermined India's federal balance by reducing the fiscal autonomy between the states and the center. So the hypothesis which I have given for this paper is that whether the GST system has significantly reduced the fiscal freedom of states by centralizing taxation powers under the GST Council, making states structurally dependent on the center. So the major objectives of my paper includes to analyze the constitutional framework of the 101st Amendment, to evaluate whether the GST Council as a mechanism of cooperative federalism is effective or not, and third, to propose reforms that restore meaningful state fiscal space. So the research methodology adopted for the paper is broadly doctrinal, focusing on constitutional interpretations, judicial analysis, and federalism structure. So, first, with respect to my first research question, analyzing the constitutional framework of the GST system. So, first of all, the goods and service tax was introduced with the 101st Constitutional Amendment in the year 2016. So, it was aimed to restructure the entire fiscal architecture of the Indian taxation system. Earlier, it was value-added taxation system. So, this was changed with effect from 2016 as the goods and services tax. So Article 246A granted concurrent power to both Parliament and state to legislate on GST. Article 269A ensured that the integrated general goods and services tax will be implemented when there is a interstate trade and commerce applicable between two or more states. And Article 279A establishes the GST Council, which is a constitutional body headed by the Union Finance Minister, Minister of State, and state finance ministers. Article 366(12)A defines GST but excludes alcohol and petroleum, reserving limited state revenue. Most critically, the seventh schedule was amended to subsume VAT, excise tax, entry tax, and luxury tax, stripping states of the independent tax heads entirely and moving forward with GST structure. Article 368 provides for the compensation with respect to GST structure. So, after the introduction of the goods and service tax, what has the impact been on the fiscal autonomy of the states of the country? So, before GST, states had clear independent taxing powers. They had various, forms of taxes, that is, sales tax, excise on liquor and specified goods, entry tax, etc. So, all these were removed overnight, giving more power to the center to tax on the goods and services in the country, wherein there is an apportionment of taxes between the center and the states. So the states over here are having limited fiscal autonomy over taxation as compared to VAT. They have very much limited taxation power after the implementation of the GST structure. So after the 101st Amendment, the picture has changed dramatically. States now operate within rate constraints set by the GST Council, and their revenue depends on IGST apportionment by the center. So they cannot craft independent fiscal policy for the region specific needs. So the needs of every state might differ from the other, but they don't have the independence to decide how much is the taxation that can taken by themselves without the center intervening in it. So whether there is any kind of flood or whether any agricultural distress exists in a state, they don't have the autonomy to increase or decrease the taxation power within their state with respect to the surrounding needs. So in short, the tax base is shared, but the power is not. The comparison of cooperative federalism in theory and practice. So whether the GST Council fulfills the constitutional objective of federalism, whether there is cooperation between the center and the states in reality, or it is just a letter in law. So with respect to this, if we can analyze, the GST Council was designed as the heart of the cooperative federalism. So the states were considered to be equal participants in the council's decisions, and the decisions are shared by a three-fourth majority. So all the states were equal participants along with the center, and the council's recommendations were advisory under Article 379A4, Clause 4. But in practice, so the provision of the law states, that the state and the center have equal opportunity to participate in the GST taxation system decisions. But in practice, the center alone holds one third of the total voting weight, which means it can single handedly block any resolution. So the states need three-fourths among themselves to pass anything if the center abstains. More critically, while the council's recommendations are legally non-binding, states are politically unable to deviate from them. So many scholars have noted that the center has more power in the council. So in practice, the states are not equal participants in the GST council decisions. So the key judicial pronouncements or cases with reference to this, title, GST and cooperative federalism. First is the main case, Union of India versus Mohit Minerals. It is a 2022 case. So the
You
Supreme Court
have two
held in
minutes more,
this case
ma'am.
that, okay, ma'am. Okay, ma'am. So the Supreme Court held in this case that the GST Council recommendations are not binding on the Parliament or state legislatures. Both centre and states retain independent legislative competence under Article 246A. And second case is with reference to National Capital Territory of Delhi versus Union of India. So the constitutional bench in this case held that the framers intended centre and states to work collaboratively, not at cross purposes. So cooperative federalism requires coordination within respective spheres, neither subordinate to the other. So the third case is with reference to state of West Bengal versus Union of India. So India's quasi-federal structure allows center to override, certain decisions for national interest. So GST centralization fits within this design, but it must not extinguish state autonomy entirely. And fourth and the last case, Jindal Stainless Limited versus the state of Haryana. So here the Supreme Court abolished the compensatory tax doctrine and struck down the interstate trade barriers, clearing the constitutional path for GST. So revenue dependency and compensation and analysis. So the compensation architecture reveals just how structurally fragile state finances became under GST. States were promised 5 years of revenue guarantee from 2017 to 22, financed through compensation cess. But when COVID devastated cess revenues in 2020, states were left without any recourse and were forced to borrow. So the cess was then exceeded to 2026 not to pay compensation, but to repay loans the center had taken in behalf of the states. So this exposed four structural problems, and so the voting
Uh,
structure.
your
Ma'am, the time
time
is
is
up.
over.
Can
Ma'am, can I
No,
get another minute just
no,
for
no, no. You
concluding?
can't. You can't. Sorry.
so
We
sorry
okay. It's
about
okay.
it.
Okay. Now we have a question for you.
Okay, sir.
Just consider a scenario where a kind of child, okay, of class 7 comes to you and wants to
Okay.
understand this topic, and in
Okay.
5 lines you have to explain that student about what you have spoken right now. How will you explain that person or that student? Just in
Sir,
simple you have to explain that thing in very simple words, okay?
okay,
Because
sir.
we are saying that yes, the kind of presentation you have given, good, fantastic, but the things changes when we say that okay, this is very complex topic and you have to explain this thing to a class 4 or a class 7 student, right? How will
Okay,
you
sir.
explain it?
Okay. So starting with what exactly is the meaning of federalism? So federalism is a concept wherein there is equal sharing of power between the center and the states. So with respect to India, there
Please,
are
okay,
28
just a
states.
second. Please make sure you are explaining it to a class 7 or a class 4 student, and
Okay.
he might not understand these terms. So you need to consider these things.
Okay, sir. Okay. So India as a country has 28 states, right? So each state has separate powers differing from the center. So there is a union government at the central level of the country which makes laws for the entire country as a whole. And there are 28 states. Each state has its own territory and it can make laws within its territory, right? So with what is a tax? Tax is basically when you're going to buy any thing from the market. Suppose you're buying any ketchup bottle or you're buying any fruits or something. So when you're buying it, suppose the cost of the product that you're buying is 50 rupees. In that 50 rupees, 3 rupees will go as tax to the government because the government is providing you this product. It is providing you with certain services. So you have to pay a small amount of the MRP to the government. So that is called as tax. So basically, you're paying a little amount along with the product's value to the government. So this is called tax. So there are two types of tax. One is directly you're paying to the government and one is indirectly you're paying to the government. So the example which I gave is with respect to indirect taxation. So you're paying 3 rupees of tax for the fruits that you're purchasing or for the product that you're purchasing from the market. So this tax goes to the government. So after now GST, this is called as goods and services tax. Now goods and services tax, this rupees 3 will be
Okay, okay,
will
okay, okay, okay. You can stop right now. Thanks, ma'am, for explanation. Your time is over. Okay,
okay, sir. Thank you.
thank you. Thank you, ma'am. Okay,
Yeah.
Pallavi, are you there?
Yes, sir.
Uh,
Can I share the screen?
just a second. Yes. Yeah, go on.
Good afternoon, everyone.
Just a second.
At first, I would like.
Just a second.
Okay, sir.
Yes, now you can go.
Okay. Good afternoon, everyone. At first, I would like to take this opportunity for giving me this platform to present my paper titled Constitutional Protection of LGBTQ Rights, a Global Comparative Study through the lenses of morality and transformative constitutionalism. So this paper provides a comparative analysis of global legal landscape of LGBTQ rights, highlighting both progress and challenges. Despite the growing recognition of diversity in sexual orientation, gender identity, and gender expression, the international legal landscape remains deeply divided. On one hand, a steadily increasing number of states have moved towards marriage equality and gender recognition and anti-discrimination protection and inclusion in the constitutional framework. On the other hand, there is still uh, they are not getting they are getting discrimination on the ground level. So hypothesis of my study is firstly, most constitutions do not clearly mention LGBTQ rights. Second one is transformative constitutionalism helps in achieving equality. So, talking about the objective of my study, firstly to understand how different countries protect LGBTQ rights, then to study the role of constitutional morality and to explain the transformative constitutionalism, then to compare the constitutional provisions and what they related to the LGBTQ rights in India, South Africa, UK, and US, and to identify the legal gaps and challenges in the ground level for protecting their rights. So this paper is completely doctrinal and comparative research is done for completing the research. Now talking about the constitutional morality, it means the decision should be based on constitutional values and not based on public opinion. It protects the minority rights even if society doesn't accept them. Second is what is constitution, transformative constitutionalism. It means the constitution is a living document and it can bring social change and equality through progressive interpretations. Now, before discussing the position in India, I'd like to discuss the international legal framework for LGBTQ rights and the recent global challenges. First, at the international level, there is no single law that can directly protect their rights. However, important human rights treaties like International Covenant on Civil and Political Rights play a major role. The UN Human Rights Committee has interpreted the treaty to include LGBTQ plus person under rights such as privacy, equality, and freedom from discrimination. Even in the case of Tunan versus Australia, the criminalization of same-sex relations was held to violate the right to privacy, and later in the case of Young versus Australia, further confirmed protection against discrimination. Even in United Nations also promotes this rights through tools like universal periodic review, where countries are encouraged to decriminalize same-sex relations and adopt equality law. Moving to the regional systems, Europe has made significant progress through the European Court of Human Rights. Uh, in in the case of uh, Judgen versus UK, the court recognized same-sex intimacy as a part of private life. Similarly, in Africa has taken a slower steps, but the institutions of African commissions of human and people's rights have condemned violence and discrimination against LGBTQ rights, LGBT individuals. Now, talking about the position in India, Constitution doesn't clearly mentions what is LGBT, and there is no particular uh, uh, provisions for particularly dealing with them. But the court has protected their rights using Article 14, 15, and 21. In the case of Navdesh Singh Johar versus the Union of India, this case is one of where Section 377 of Indian Penal Code, which is repealed now, was decriminalized, and Supreme Court withdrew the criminal charges against the homosexuality. Similarly, in Nalsa versus Union of India, the third gender was considered and given the basic rights to recognize the gender transgender persons. Now, talking about the current scenario, over 35 countries world over have legalized same-sex marriage, with notable advancement in Latin America, particularly in Mexico and Taiwan and Nepal. And but in courts and legislatures in these countries have recognized that
You have
exclusion
2 minutes
from
more,
marriage.
ma'am. You have just 2 minutes more.
Okay. Uh, okay. Now talking about the challenges in the current scenario. So even today, many challenges exist that many countries still resist these rights due to cultural and religious beliefs. There is also an enforcement gap, meaning even when laws exist, they are not properly implemented. Recently, there has been a backlash, like countries like Uganda, Ghana have introduced strict LGBTQ laws, and Uganda's 2023 law even includes life imprisonment in some of the cases. Even in Europe, which is considered progressive, there have been rise in restrictive policies, especially in countries like Poland. So, at last, I would like to conclude my presentation by saying that legal recognition of same-sex marriage is should be given because that is one of their fundamental rights under Article 21 of the Indian Constitution. Apart from that, there should be stronger constitutional protections, uh, and Constitution should clearly protect LGBT rights. Moreover, there should be awareness and education in the schools and colleges level to reduce the stigma so that they should come forward and address the issues which they are facing. Even the court should continue to support LGBT rights, and the legislature should come forward by learning from the
Ma'am, your time
different
Your
is
time
countries'
is
over.
laws.
up, ma'am.
Your time is over.
With this, I'd like to conclude my presentation.
Okay. It was a lovely presentation because you have presented on a very sensitive topic. Now the question is, consider me as a very patriarchal, very conservative, very sexist, very
Okay.
classist kind of person. Okay,
Okay,
how
sir.
would you convince me within a 1 minute that I should side with the people who are from the third, who are basically who are other genders or who are homosexuals, okay, who are lesbians, who are gay, who are looking for same-sex marriage. How would you actually convince me, or how would you change my mind? Okay, obviously it will take a lot
Sir.
of time, but what can be that strategy of yours where you will actually change my mind and where I will say earlier I was wrong, today I am right. Today I think that these people do deserve rights. But please note, I am very patriarchal, I am very classist, I am very sexist, I am very conservative. I don't care about their rights. How would you explain? How would you change my mind?
Sir, at first I'd like to mention that as you have in your question you have also mentioned that it is not easy to convince within a few minutes. So, also, if someone is very stubborn that he don't want to change his mindset, it is not possible at all to change his mind. But with the examples that still now how the transgender peoples are growing in their professional field, some of them are holding very higher authorities. They should get their basic rights, like basic education, that employment in the employment growth in the employment sectors, and to having same-sex marriages is a part of fundamental right. So that is the basic thing. Law is what is the purpose of law? Law is to safeguard the people for their basic rights, and we all know what is our rights. So if a person is very much patriarchal and he doesn't uh, want to accept this concept, one thing can be said that they are also part of our society, and if we can't uh, help them to grow, that our country cannot able to develop, because ultimately they will have to suffer a lot.
Okay,
That's
ma'am.
all.
Thank you, ma'am. Okay, thank you. Priyanshu, are you there?
Hello.
Yeah. So, yes. Okay, just a second. So Priyanshu, are you going to present or Divyanshu going to present?
So I will present. So
Okay, please start.
okay. So, uh, so is my PPT is visible? Hello.
Yeah,
Yes,
your
Priyanshu,
paper is
it's
visible.
visible.
Okay. Thank you so much. Just a second. Okay. So good afternoon, everyone. So my just a minute. So my topic of presentation is, and my title of the paper is Crossroads of Equality and Humanity, as a legal analysis of India's outbound migration to Europe and the inbound migration throughout its eastern borders. As talking about migration is not a new concept. It's a natural and continuous human phenomenon that has excited throughout history. As people have always moved from one place to another in search of better opportunities and safety and survival. As however, in the modern context, migration is no longer just a social or economic issue. It has become a complex legal and policy concern influenced by factors such as economic inequality, lack of employment, and due to political instability. As India became a very unique situation in this regard, as one hand it acts as a source country where many individuals migrate abroad, often through illegal means, in search of a better lifestyle. On the other hand, India is also a destination country, as receiving a large number of migration from neighboring countries. As what is particularly concerning is the rising trend of illegal migration, where individuals are forced to take dangerous and unauthorized routes, often falling prey to agents and trafficking networks. What is particularly concerning is the rising trend of illegal migration, where individuals are forced to take dangerous unauthorized routes. So, taking about from the legal perspective, this creates a sincere challenge relating to border control, national security, and regulatory mechanism. As at the same time, we cannot ignore the dimension, as migrants are entitled to basic human rights and dignity regardless of their legal status. Therefore, the issue of migration towards standard at a critical crossroads between illegality and humanity. As talking about the problems and the scale, the issue of migration in India is not just a theoretical, as it becomes a serious and large-scale problem in recent years. As one of the most visible aspects is the sharp rise in the illegal outbound migration, particularly from states like Punjab, where many individuals attempt to reach country in Europe and North America through unauthorized means. As a major concern here is the use of dangerous routes, commonly referred to as a donkey road, where migrants travel through multiple countries without proper documentation, often risking their life in the process. As at the same time, India also faces challenges of illegal inbound migration, especially from neighboring countries, weaker border management due to some weaker border management and geographical vulnerabilities, as it makes a difficulty to fully regulate such movement. As from a legal standout, the scale of this issue is quite alarming, as thousands of Indians are detaining or deported every year, and globally illegal borders crossing continues to rise. As talking about what are the causes of the migration. So first cause, due to some of the economic hardship, as people are not getting employment. Next one is closely related to agrarian distress, particularly in rural areas where declining agricultural income and increasing debts burden people to migrate in search of some of the financial security. As another important factor is the desire for a better standard of living, as many individuals are motivated by the aspiration to earn more, access better education, and to improve their overall quality of life. And at the same time, social media influencers play a significant role in this, as the success story of family members or peers settle abroad often creates pressure and encouragement to follow the same path. As in the case of inbound migration, political instability, conflict, and persuasion in neighboring countries compel individuals to cross borders in search of safety and survival. As finally, structural issues such as regional inequality and lack of developmental opportunity further satisfy the migration pressures. Talking about the legal frameworks in India. First, now moving to the legal framework, India does not have a single unified law on migration. Instead, the legal regime is
You have just
fragmented
2 minutes more.
multiple status, uh, addressing different aspects of migration. Firstly, the Immigration Act 1983 that regulates overseas migration. Second, the Foreigner Act 1946 that empowers the government to control the entry, presence, and deportation of foreigners. Third, the Passport Act 1920 deals with the travel documentation and penalties individuals who attempt to leave or enter the country without any valid authorization. As there is another act, that is Indian Penal Code, that is now Bharatiya Nyaya Sanhita, which plays a crucial role in regarding the human trafficking, cheating, and forgery. As there is another act, the Citizens Act 1955 further determines that the legal status of individuals in terms of citizenship, naturalization, and identification of illegal migrants. As talking about the constitutional and judicial perspective, as it is important to know that the Constitution of India does not exemplarily provide the right to migrate or settle in a country for non-citizens. However, certain fundamental rights are still extend to all persons irrespective of citizenship. For instance, like Article 14, which guarantees the right to
Okay,
equality,
okay, okay.
applies to
Sir,
both
you have to
citizens
stop.
and non-citizens.
Sir,
This means that,
sir, you have to stop right now. This time is over. Okay, it was
so
good.
shall I conclude?
Yeah, you have to
Just
conclude right now. Just conclude, please.
okay. In 2 or 3 lines, I will conclude it. Okay. Hello.
Yeah, please go ahead.
Okay. Thank you so much, sir. As talking about the conclusion part that I am regulating and what are the recommendations that I would like to give, as it is equally important to modernize existing laws, particularly the Immigration Act, so that they are better suited to address the complexities of present day migration patterns. As another key area is the strict regulation of recruitment agents, as many cases of illegal migration originate from fraudulent practices and false promises made by such intermediaries.
Okay,
As
okay, sir.
lastly,
Thank
enhancing
you. Thank
international
you.
cooperation through bilateral and multilateral framework can significantly improve the management of cross-border
Okay,
migration
sir,
issues.
sir,
As
sir,
in
sir, you have to,
conclusion,
sir, stop, please. Yes. Thank you, sir. Okay. Shiva, are you there?
Yes, sir.
Okay. So kindly
Wait,
please do your presentation.
wait a minute.
Yes.
My PPT is visible.
Yes.
Okay.
I think is it is not the first slide.
Oh, okay, okay.
Just
Good afternoon. I'm Shiba Khan. I will presenting my paper. Title is Digital Surveillance and Constitutional Justice, Balancing State Power with the Right to Privacy. And uh, India is increasingly moving towards a model of data-driven governance where technologies such as artificial intelligence, facial recognition, and centralized databases like the Central Monitoring System and the National Intelligence Grid are widely used. Unlike traditional surveillance, which was targeted and based on suspicion, modern digital surveillance is continuous, automated, and often indiscriminate. The shift fundamentally changes the relationship between the state and the individual, creating what scholars describe as surveillance society. Research problem, the central issue is the tension between legitimate state interest such as national security and the individual's right to privacy. In many cases, surveillance is conducted without prior judicial authorization, relying heavily on executive discretion. This raises the risk of transforming a democratic system into a surveillance based governance model where citizens are constantly monitored. It also leads to a chilling effect, discouraging free speech and democratic dissent. This paper aims to critically examine the legal framework, govern surveillance, analyze constitutional protections of privacy, and evaluate whether current practices meet the standards of proportionality. The methodology is doctrinal, focusing on judicial precedents, statutory provisions, and academic analysis. This approach helps in identifying gaps between law and practice. Digital surveillance involves systematic collection of data and analysis on a large scale. using advanced technologies. Advanced technologies also includes interception tools like the Central Monitoring System, National Intelligence Grid, network analysis for analyzing of trafficking, internet trafficking includes the bomb attacks and attack on the sovereignty and integrity of India. Scholars describe this as a shift from reactive surveillance to predictive surveillance where behavior is anticipated using algorithms. This includes facial recognition systems. Such systems enables real-time tracking and profiling, raising concerns of mass surveillance rather than targeted investigation. Constitutional framework. The right to privacy is constitutionally protected under Article 21 as a part of right to life, where privacy is identified as a fundamental right as a part of right to life and personal liberty. It is also supported by Article 14, which prevents arbitrary state action, and Article 19, which guarantees freedom of speech. In a landmark judgment in 2017, Supreme Court of India, Justice K.S. Puttaswamy versus Union of India recognized privacy as a fundamental right. It also includes a proportionality test.
Ma'am,
The
you have 1 minute to
proportionality,
go.
okay, sir. Importantly, the court introduced the concept of informational privacy, giving individuals control over their personal data. Despite constitutional safeguards, surveillance is governed by outdated and fragmented laws such as Telegraph Act 1985 and the IT Act 2000. Section 69 of the IT Act allows interception and monitoring of digital communication for broad purposes like national security. However, these powers are exercised primarily by the executive with minimal independent judicial oversight. This creates a significant gap between constitutional ideals and ground realities. The doctrine of proportionality is a key constitutional safeguard used to balance state power and individual rights. It ensures that state adopts the least restrictive means while pursuing its objectives.
Ma'am, your time is up.
Sir, can you please give me a minute to conclude?
Okay, take.
I'm so
Okay, okay. Just take 10 seconds, please.
In conclusion, I would like to say that while surveillance is necessary for governance and security, it must operate within constitutional limits. There is a need for prior judicial oversight, stronger data protection laws, and transparency in surveillance practices. A rights based approach must guide technological governance to ensure that efficiency does not override fundamental freedoms. Ultimately, constitutional justice lies in maintaining a balance between state power and individual liberty.
Ma'am, your time is over.
Thank you.
Okay.
Okay, sir.
Nayana, I want to ask her anything? Any question?
I have a question for you, ma'am.
Yes.
Do you really think that people in India are fully aware of how much data is being collected and monitored? And also, can you please tell me about the DPDP Act if you're aware of?
Yes, the DPT Act also amend in 2025, and it also introduced new reforms to collect and analyze data properly, because the citizens of India above the age of 60 plus, they are not aware of the internet, and also they did not know what kind of spywares and data monitoring systems are used and analyzed. Uh, so there has been an amendment in DPD Act.
Okay, ma'am. Perfect. The next we have Ashish. Are you there, Ashish?
Yes, ma'am, I'm present over here.
Okay. Are you ready with your
Shiva, can
PPT?
you please unpresent that slide, please?
Yes, sir, yes.
Yes, ma'am, I'm ready with the PPT. Yeah, before I start the presentation, I would like to ensure the mail was received by the body.
Yeah, yeah, we received your mail.
Then I will proceed with the
Yeah,
presentation.
please present your PPT first.
Sir, is the PPT visible?
Yeah, we can see it.
Good evening, everyone. My name is Ashish Joel, and today I will be presenting my research on judicial review and constitutional courts, which is a global comparative study. Constitutional governance is based on a simple but difficult question: how does the law control the very power it creates? This study looks at how different legal systems, ranging from the common law to the Islamic legal traditions, use their courts to make sure the government stays within its legal boundaries. Coming to the research problem, the main problem I addressed is the risk of arbitrary power. Sometimes governments pass laws or take actions that go beyond what the constitution has actually allowed them, which can threaten our fundamental rights or even the soul of the democratic nature of a country. This creates a tension on how can unelected judges review the work of democratically elected leaders. To exploit this, my research has three main goals. First, to understand the reach of judicial review over laws and executive orders. This includes the maximum possible scope of judicial review and what are the elements it has authority over. And then, second, to compare different systems and different legal systems like the American model of judicial review, which is a decentralized model, and the European or the Kelsenian model of judicial review. And third, to see how different legal systems, such as the civil law system, the common law system, and the Islamic law system across the world, handle these constitutional checks. For my research, the methodology I used is a comparative legal analysis, which is based completely on doctrinal resources. The primary resources I have used for this research included uh, existing and operational constitutions of different world nations, and then the uh, court proceedings and precedents given by the courts supporting the constitutions. This means I studied the constitutions and court rulings of various countries to see how they differed from one nation to another. In my analysis, I found three main countries and three main ways the countries do this scrutiny. These models include the American model. This is a decentralized model of judicial review where any court can declare a law unconstitutional or exercise the power of judicial review over any action on behalf of the government. And then coming to the European model or the Kelsenian model of judicial review, where only one special constitutional court exists, and that court alone possesses the power to exercise judicial review and scrutinize the government actions. And then there is the hybrid model, which is clearly observed in the Indian context. In India, there is neither a completely decentralized system of judicial review such that each and every court are authorized to exercise the power of judicial review. However, it is not limited to a single court, but it consists of a hybrid model consisting of empowering the high courts and the supreme courts alone to exercise this power of judicial review and then scrutinize each and every action of the government to ensure the supremacy of the constitution. And then uh, coming to this research primarily established and studied the global standards of scrutiny over government actions in different constitutions, where courts use specific tests like the proportionality test observed in the German constitution to declare if a government's restriction on a person's right is actually fair and necessary, or the Oakes test, which ensures that an act of the government lies within the scope provided by the Constitution. In this research, there are primarily three main case laws, the precedents that support the arguments on behalf of judicial review. These include at first, the US precedent of Marbury versus Madison case, which established that the courts have the final say on what the Constitution means. Basing on this precedent, the American decentralized model of judicial review was established for the first time. And then in India, we have seen vital doctrines develop from the cases like doctrine in the case of A.K. Gopalan, the doctrine of severability was established, which allows a court to strike down just a bad part of a
You
law while
have just
keeping the
1 minute
rest
to
of.
go.
And then coming to the other case, in the case of Ramesh Thapa, the court provided that it would protect free speech against laws that were inconsistent with our fundamental rights, providing a scope for judicial review over laws which are inconsistent with the fundamental rights. And then the most important precedent comes to the basic structure. Now, looking specifically at the Indian approach, our system is quite unique. Unlike many countries, India has identified unamendable basic structure, which was established in the case of Kesavananda Bharati. This means there is a core part of our constitution that even parliament cannot amend or change. Our courts exercise a very broad power of review. They do not just look at simple laws, they even review constitutional amendments. This creates a dynamic balance where the courts act as a guardian,
Okay,
ensuring
okay,
that
sir. You
the
can,
government can lead.
sir. You have to stop. Your time is over. Thank you,
So,
sir.
I would I mean, can I conclude
No,
my
no. Sorry,
presentation?
sir. Please, sir. Time is very limited, sir.
Okay, sir. Thank you for listening, and I would now be happy to answer any questions you have regarding medicine, sir.
Imagine you are the prime minister of the country, okay? And
Yes, sir.
you have got the majority, the complete absolute majority. So you have around 500 MPs of your own party, okay? What would be the first thing that you would do in regard to the topic that you have just presented right now? What two bills you would like to pass, firstly?
Sir,
Secondly, just a second. We'll just hear our question first. What two bills you would like to present? Okay, and one can be a money bill, other can be an ordinary bill. Okay, as you have the 500 members, so you can do uh, an amendment under 368. Okay, and there will be no challenges for you. So yes, and also to make things very easier for you, India has 28 states, right? So
yes, sir.
almost in 26 states you have your own party ruling. So right now, please tell us two bills you want to pass in regard to what you have just presented.
I mean, given this scenario where I was the prime minister with the utmost possible majority, uh, people believe or simply believe that since there is no proper opposition, people believe that the exercise of power can even turn tyrannical. But given to the source of authority which I have derived comes from the very constitution,
Sir,
and
we
even
have
though
asked you about the two bills. Just state the two bills.
coming to two bills, even though I mean the very first bill comes to um, liberalizing the scope of uh, legislating powers between the state and central, even though the basic structure doesn't talk anything about the union lists or the concurrent lists in specific. I would like to bifurcate them completely in such a way that whenever uh, the union wants to make a decision in a particular state, there should be no constraint or no restriction, so that the central
So
idea
you
of the
you
union
just a
government
second,
gets exercised.
just a second. So you want the union to have a complete absolute authority over the state.
In particular matters, not
In
all,
what
but
matters?
um, when it comes to irrigation and forestry, or even there are some certain.
Okay, one more thing. For, suppose a person who is from Delhi, okay, suppose, okay, now he's the prime minister. He has absolute he has no knowledge regarding the irrigation culture or the farming culture in Tripura, the northeast. How would you think that central will take the right decision, or uh, don't you think that it is the state, because the people who are in the administration of the state are actually, they do understand the farming culture of that particular state much better than the center.
It is possible that the state or the leaders of a particular state will be well familiar with this conditions of farming and all. But however, when uh, I mean, even the union has a proper representation in the state, so it would be better. I would follow the advice from. I mean, I would like to have an advisory opinion rather than a binding opinion from the states. In such a way that whenever I feel like making a decision regarding the irrigation or agriculture in a particular state, I wish for. For example, consider
Okay,
like
okay, okay,
um,
okay, okay. Thank you,
yes,
thank you. Okay,
thanks.
Mania. Okay, you can now switch off your presentation. Thank you, sir. Okay. Now, Mania Agrawal, are you there?
Yes, I'm there.
Yes, you can do your. You can please do your presentation.
So if it's fine by you, can I turn on the video so that it's a bit interactive?
No, please present your paper.
All right. Is my screen visible?
Yes.
All right. Greetings to the dignitaries and everyone present. I'm Manya Agrawal, and today I'll be presenting my paper titled From Protection to Prejudice: Legal Blind Spots in Women's Rights Laws and Men's Unprotected Legal Spheres in India. Let me begin with a thought. Laws are often created to protect the vulnerable, but a question that compelled me to write this paper was what happens when protection over time unintentionally creates exclusion? In recent years, India has witnessed a series of deeply troubling incidents where individuals, particularly men, have expressed a sense of helplessness within the legal system. It was this gap between the legal intention and lived reality that motivated me to explore this topic. The basis of this paper is the contemporary legal issue of men's rights, which has gone neglected in the past few years in light of protecting women from social inequality and atrocities faced by them for a long time in a patriarchal society. This led to my central question whether laws that were once instruments of justice are now, in certain cases, creating legal blind spots. To answer this, my research examines the constitutional foundation, identifies gaps, analyzes real world impact, compares global frameworks, and finally proposes reforms. Now, moving to the core analysis, the Indian Constitution guarantees equality under Article 14. At the same time, it allows what we call positive discrimination under Article 15 and 16. This is important because women centric laws were never arbitrary, they were a response to the historical injustice. Special laws came into force as needed since women victims of crimes such as domestic violence, cruelty, dowry death, sexual harassment, rape were in large numbers. Today, the assumption embedded in many laws that harm flows only in one direction does not always reflect reality. This creates what I refer to as the legal blind spots, where the law is not absent but incomplete. Thus, constitutionally and ethically, if women are entitled to special protection and laws, men too are entitled to similar legal recourse when faced with harms such as cruelty, domestic violence, or maintenance related injustices. If we look at specific legal provisions, which I have listed in pointers, this becomes clearer. These mentioned provisions clearly and solely protect women, which was indeed the need of the hour to embed them in the legal framework. However, no recognition is given to men as victims, and no other parallel recourse is available to them when they face similar circumstances. For instance, laws relating to sexual harassment recognize only women as victims. Don't men face harassment? Provisions dealing with cruelty in marriage or domestic violence largely operate on the assumption that only women can be aggrieved. Can't men face such cruelty from the other side? Workplace harassment laws are similarly structured. The issue here is not the existence of such protections. The issue here is exclusivity. Because when the law does not even recognize the possibility of a male victim, it effectively denies access to justice. Now, if we examine the judicial response, we see that the judiciary has acknowledged these concerns in these cases. In certain cases, courts have pointed out that the misuse of provisions have taken place and have suggested the need for caution and reform. Safeguards have been introduced to prevent arbitrary arrests and a need for a more balanced approach. However, these are largely interpretive corrections. The structural framework of the law remains unchanged, which means the meaningful reform must come from the legislature. This brings me to the current legal landscape and societal impact, and this is, in my ways, the most crucial part of my paper. We are witnessing a shift in societal discourse. Cases that have come into public attention in recent years have sparked widespread debate. There is growing awareness, increasing public dialogue, and even movements that highlight the need to recognize men also as potential victims. We all are aware of the Bangalore techie Atul Subhash suicide case, 81-minute video, a 24-page long note alleging false cruelty cases, and he lost his life because of the mental and financial cruelty done to him at his wife's end. It triggered the national #MenToo movement as well. Similarly, the Mohit Yadav case, where he penned down specifically, if there was a law for men, maybe I wouldn't have taken this step. He also lost his life. Therefore, if there was a law for men as well, if there was a legal remedy for men as well, we wouldn't have lost so many lives. Now, it is very important to approach this carefully. This is not about denying the very real and serious injustices faced by women. It is about acknowledging that harm in today's society is not always unidirectional. To understand whether this is a uniquely Indian issue, I conducted a comparative analysis. In countries like the USA, legal frameworks relating to sexual offences and workplace harassment are largely gender neutral. The UK, the United Kingdom, incorporates gender neutral provisions in related offences. Similarly, South Africa adopts a fully inclusive approach by defining offences in terms of any person. The global trend is clearly moving towards gender inclusive justice, where the focus is on the nature of the harm rather than the identity of the victim. Based on this analysis, my conclusion is not that these laws are unjust, but that they are incomplete in the present context. While special provisions for women and children are justified, it should not ignore the rights of the other half. A crime, regardless of how frequently it occurs, should be punishable by law if justice is to be inclusive and equitable. Therefore, I suggest reforms such as making sexual offense laws gender neutral, extending domestic violence protections, introducing safeguards against misuse, and adopting a more balanced approach in such laws. It needs to be ensured that men too feel safe, heard, and secure in our legal system. Considering the influence of education and perception, children also need to be brought up in gender neutral environment without having gender stereotypes embedded in their mind, such as boys don't cry, women belong to the kitchen, and various other gender roles. To conclude, this issue is not about choosing between men's rights or women's rights. It is about moving towards a framework of gender justice in its true sense. In fact, it aligns closely with the United Nations Sustainable Development Goal number 5, which aims to achieve gender equality. Because ultimately, a legal system committed to justice must ensure that no individual is invisible before the law. Thank you.
Okay, thank you, ma'am. Now the question is for you. So imagine you are the prime minister of the country, okay, and you have absolute majority, 500 seats, okay, and now the question is, because you have said that men do deserve that kind of protection, that the extra protection that women gets. Now the question is, when we see the numbers, okay, yes, there has been serious crime against men done by women, but the thing is, society, the violence done by men against women is huge. The proportion, okay, it can be like, if the violence against the women is 9, then men can be 1, or it can be 6 or 4, 6 is to 4. Now considering this kind of proportion, okay, how would you draft a bill? Because society, oh yes, obviously you are considering these factors also, but you have to consider the chilling effects also. Yes, you are saying, because I have seen the presentation, the presumption of the guilty. Please note one thing, the presumption of the guilt is done by the society, not by the law. Anywhere if you go, if you see the presumption of the guilt, okay, uh, that that person has actually committed crime is not done by the law, but rather it is, considered by the society. So there's a kind of distinction that has to be made. So now the first question that I want to, only the question that I want to ask, what kind of bill you want to pass and what will be the characteristic to solve this issue? Considering the very fact, this proportion, that 6 is to 4, okay, and also we have seen certain judges who are showing a great amount of biasness against men. Also you need to consider that the violence against women is huge. How do you solve this issue?
Thank you for the question, sir. Firstly, I would like to mention that my presentation and my paper was merely that reforms need to be done. So, not special laws need to be made for the men, but maybe reforms need to be done in the existing laws. Coming to your question, if I need to pass a bill, uh, so keeping all the circumstances, the proportion of crimes against men and women, keeping all that into mind, I still would pass a bill mentioning legal recourse to men, because the present scenario is that there is no legal recourse to men, because of which Atul Subhash and Mohit Yadav and so many other cases have come into our sight of suicide, because there was no
So
legal
then it is actually special law. If
sorry,
you are,
sir.
when you are saying that in special legal laws for men, so it's a special law.
Uh,
So
sir,
when you say that you're going to pass a bill for the men, it's special law. It's not a generic law.
that's what I was mentioning, sir,
Hmm.
that my paper was about bringing reforms in the gender laws. However, coming to your question, wherein I have to prepare a special bill for men, I would include all the recourse or the legal uh, recourse to men for all the crimes such as domestic violence as well, cruelty as well, sexual harassment as well, which are not present in the Indian legal framework for now, and this would not prejudice against women as well. Women have their special protections. However, some legal recourse will be given to men in this bill, wherein it is kept in mind that such crimes can take place against men as well, and men are not only to be seen as the perpetrators in such crimes, they can be the victims too.
So it means that we in India we cannot pass a generic law in totality. There has to be certain kind of special provisions for each genders, right?
So not specifically, we can bring reforms in the current laws, such as we can the laws which are already there for women. We can bring reforms in that. We can make them gender neutral. We can make them available for the third gender as well, the LGBTQ as well.
Okay. Thank you, ma'am.
Thank you, sir.
Yes. Nasreen, are you there?
Yes, sir.
Yeah, please start your presentation.
Yes, sir. Give me a minute. Sir, my PPT is which can you say it?
No, we can't see your
Um,
PPT. Yeah, right now we
Now it
can
is
see.
visible.
Okay. May I start?
Yes, yes, please continue.
Okay. So good afternoon, everyone. I am Nasrin Aliparambil. So today I'm presenting my research paper titled on technology, surveillance, and digital constitutional right, a constitutional analysis in the age of surveillance, capitalism, and artificial intelligence. So let me begin with a striking observation that opened my paper itself. So here you can see that the smartphone and ordinary citizen carry today transmit more behavioral data than any Cold War surveillance apparatus could have gathered in a lifetime. So here, this single sentence encapsulates the core problem that I would like to address here. We live in a society where our data are about the movement or the conversation we have made, the association, and even our biometric identities is harvested and monetized at an unprecedented scale. So this paper draws on landmark decisions like Puttaswamy from India, Carpenter versus United States, and the EU's GDPR and AI Act to argue that while our existing constitutional doctrines are genuinely an achievement, but they are structurally insufficient to address AI driven surveillance. And I would like to conclude with five concrete normative recommendations for this reforms itself. Four converging technologies forces defining what I call the contemporary surveillance landscape today. The first one that exactly that would be the AI, artificial intelligence, and the second one would be the biometric systems, where we can see the convertible erasable our bodily characters. So we could see that our fingerprints, the iris scan that we took, and facial geometries. So here all these are into a permanent digital identifier. Unlike a password, we cannot change our face itself. And the third one would be the big data ecosystem. And the fourth one that is state operative or the communication interceptions. So each of these forces, individually or in combination, exerts immense pressure on the constitutional guarantees that were designed for the pre-digital analog society. As the Samuel Warrens and Louis Babbage wrote in the Harvard Law Review back in 1819 that the law must keep pace with technology or be rendered irrelevant. So here that insight has never been more urgent than today's. Now my paper draws on three foundational theoretical framework that is by Alan Westin, that is informational self-determination, where he defined what is privacy meant to him, and that become the underpins for the GDPR's consent architecture as well as Puttaswamy's autonomy rationally becoming his four proponents. And the next one will be Michel Foucault about his panopticon servant theory. And the third one would be Shoshana suppose his servants capitalism, who even become the term or introduced the term of surveillance capitalism. And now turning now to the Indian constitutional jurisprudence, that is the landmark Indian response in the Puttaswamy versus Union of India in 2017. A nine-judge unanimous bench overruled the decades of precedents and established the privacy as the fundamental rights and flowing from Article 14, 19, as well as 20 of the Indian Constitution. So here Justice Chandrachud articulated three dimensions of privacy, that is practical privacy, decisional privacy, as well as the informational privacy itself. And moreover, the court also gave us a proportionality framework, that is, any state surveillance must satisfy the proportionality framework that given under the case law, that is the legitimate aim, which means the main purpose of the soul of the issue, then the rational nexus, the necessity, as well as the proportionality strict sense, which means the balance that could keep into it. And now I'm taking you into the internet shutdown. That is in the case of Anuradha Basin versus Union of India. In 2020, it held the shutdown engages fundamental freedom and must be proportionate. Yet, you can see that India continued to be hold the world record for the most internet shutdowns. And why that? Because it is just because the review committee scrutinizing shutdown orders. It and that is composed exclusively of government officials, like how the Fox is governing like an hen house. And then come here the Aadhaar as well as. Now I'm going for the US and the Fourth Amendment evolution, that is the rebellion Fourth Amendment doctrine for the digital age, holding that cell site location data required the warrant, and the recognition that the aggregate problem, that would be the individually installed data points combined into a surveillance profile, that is far more revealing than any single piece of information. But when it comes to the case of Carpenter versus United States digital recalibration, here we can see that it overruled the third party doctrine, where the intervention of a third party has left lower court without a governing principle for the other digital data categories. And moreover, the doctrine remains dangerously in flux, which go the European Union and as well as the furthest. Now I'm going to the European Union, which go on more further, that is by introducing the GDPR. So here it is an autonomous fundamental right actually. So the EU and AI Act goes more further still, that by introducing the Article 5 clause 1 clause D, which prohibit a real-time biometric identification in public space as a rule. Moreover, we can see that
You have just 1 minute to go.
yeah, sure, sir. So I would like to go through my critical evaluation as well. So when it comes to the evaluation, the more problem are that I evaluate, that is the technology law speed asymmetry, which we can see here that but even though our constitutional doctrines suffer from a more structural feature, first one, that would be technology move in months, constitutional framework move in decades. So every gap is a zone of impurity. And the second one would be the information asymmetry that we face in the judicial review. And third one, that is the private surveillance problem. And the fourth one, that would be the court can declare the violation that they cannot design any surveillance architecture, which is a remedial inadequacy. So when it comes to the normative recommendation, I would like to put forward the five-part reform frameworks. The first and foremost would be the judicial
Okay,
authorization
ma'am,
as
you
a
have to stop.
very bare minimum.
Ma'am, you have to stop. It's time you know.
Yeah, sure, sir.
Okay, the question is, it's not a kind. The question may sound disrespectful. Okay, but it's not a disrespect question.
Yes,
But
sir.
please understand the question first. Why should we hear you? Whatever the presentation you have given right now, why should we hear you? I don't think that you made any kind of
Sorry, sir.
sense. It's not a
Sir, can
disrespect.
you repeat
Please,
once again?
so why should we hear you?
Okay, so that's a so question for me, right?
Yeah, it's a question. Why should we hear you? Uh, think that I am someone who is least interested. Okay, I
Yes.
don't care about what you say. It's not the reality. Okay, just understand the question. So why should we hear you, and why should I hear you? Why do you think that you make sense in this
Okay,
regard?
sure, sir. So, sir, I would like to put forward that here every person in this room must be carrying a single electronic device. Could be a small mobile phone and into a Mac. But every like that means that every person in this room is already being watched. It could be by governments or by corporate. even your single click, the algorithm that you can see while you're moving through your reels, and all the other things that make a part of the decision about your life without your knowledge or without your consent, that must be watched by a third person. So that would be the core reason that you should hear me, because the law that are supposed to protect us as a citizen, uh, like like nobody in this power seems to be in a hurry to fix that. That I would like to say that in this more what longest or under AI surveillance country, or in the contemporary 21st contemporary society, we could see that the more importance of AI and the usage of AI is the greatest. So if we do not ask these questions, or if we do not find the gaps between the laws, then I think that there is no a proper identity for a person to live in this country. So
Okay, okay, I get it. I get it. You have explained it nicely.
thank you, sir.
Fantastic. Kudos. Okay, thank you,
Thank you.
ma'am. Arihant, are you there?
Yes, sir.
Yeah, you can start your presentation, please.
Okay, sir.
Who is gonna present the other paper, other part?
So the first part will be presented by me, and the second part will be taken over by my co-author Jia Sarkar.
Where is she?
Yes, sir, I'm there.
Okay, so can you just tell me the slide numbers?
So the total slide numbers.
You are going to present from slide number from what to what?
Okay, sir. So I'm presenting from slide 1 to 4.
Okay, get it. Thank you.
And this, the rest of the part will be taken over by me.
Okay, please note one thing, that you people will be getting only 7 minutes. Okay,
Yes, sir.
yeah, go on.
So is the screen visible?
Yes,
Yes.
ma'am, it's perfectly visible.
Good afternoon, everyone. Today, me, Arihan Chatterjee, alongside my co-author Jia Sarkar, will be presenting on our paper which deals with the core question that whether the Indian welfare schemes truly serve the interests of the transgender community or not, or rather it relies only on the paper. Our legal presentation studies the gap uh, that how the legal promise which was made and the actual reality which is lived by the transgender community across India. To move to the next slide, despite of landmark legislation such as the NALSA judgment of 2014, the Transgender Act of 2019, the transgender person continue to face systematic expulsion from medical and healthcare facilities, job opportunities, education, and social security. The root cause of this problem lies in the combination of the bureaucratic failure, administrative hatred, and the deeply colonial hatred which was institutionalized by the British Criminal Tribes Act of 1871. To sum up, I will say that the transgender rights remain only on the paper and their actual implementation is both practically and theoretically weak. Coming to the next slide. India faces the transgender right over a span of 150 years, starting from the criminalization during the British colonial period towards the constitution recognition in today's time. The NALSA judgment of 2014 has reaffirmed the third gender status in correspondence to Article 14 and 21 of the Indian Constitution, followed by the Transgender Persons Act 2019, which has mandated welfare programs, complaint mechanism, and self-identification rights. But however, placing a legal statute in a place does not mean that its automatic translation into meaningful access. Coming to the next slide. The Indian government has launched several welfare schemes for the benefit and inculcation of the transgender community. Most notably, the SMILE schemes, such as the Ayushman Tag Plus card, the Garima Grah shelter homes, and most notably, the free legal aid through NALSA states like Tamil Nadu and Kerala through their dedicated welfare boards and anti-discrimination policies. But however, despite of this, implementation gaps such as underfunding, poor helpline numbers, digital outreach means that only a few beneficiaries are receiving these entitlements. So,
Thank you. And the rest of the presentation will be taken over by my co-author Jia Sarkar.
Good afternoon, everyone. Building upon the legal and policy framework discussed earlier, I will be now focus on the ground level realities faced by transgender person in accessing public services. Despite legal recognition, access to identify documentation remains one of the biggest barriers. The process of obtaining transgender ID cards is often delayed, complicated, and not properly linked with essential documents like Aadhaar or ration cards. In healthcare, although schemes exist, gender affirmative care is available only in limited states, and many individuals face discrimination and misgendering by medical professionals. Further, in education and employment, high dropout rates due to bullying and lack of institutional support continue to push transgender person into cycles of exclusion and poverty. Even social security measures such as shelter homes and pensions remain difficult to access due to documentation gaps and lack of awareness among officials. Moving on to the next slide, which talks about the case laws and judicial responses. The judiciary has played a crucial role in advancing transgender rights. In Nalsa versus Union of India 2014, the Supreme Court recognized transgender person as a third gender and held that their rights to equality and dignity are fundamental, placing a clear obligation on the state to provide welfare measures. In Akai Padmashali versus Union of India 2021, the focus shifted towards implementation with the court directing regular views and compliance by authorities. Similarly, in V. Vashanta Mogli versus State of Telangana 2023, the court struck down discriminatory laws and directed affirmative states such as reservations and pensions. However, this judgment also highlights that enforcement remains weak. Moving on to the next slide, which talks about the critical analysis. This brings us to a critical question: where exactly does the system fail? The key issue is not the absence of law, but the lack of implementation. The Transgender Persons Act 2019 does not provide strong grievance mechanism or penalties for such non-compliance. Institutions remain largely advisory, which reduces their effectiveness. At the same time, certain state level initiatives show that proper implementation is possible with commitment and resources. To conclude, India has strong legal framework but a weak implementation system. Substantive equality requires accountability, proper funding, and inclusive policy making. Moving forward, stronger grievance mechanisms, statutory welfare bodies, and community participations are essential. Only then we can truly bridge the gap between the law and lived reality. Because true equality is not achieved when rights are written in law, but when they are lived in reality. Thank you.
Okay. So, Naina, I want to ask you want to ask?
Yeah, so my question for you, Jia, is that if given you any authority in order to change the mindset of the society, what will be the steps taken by you so that the acceptance of this transgender can be easily done and people should respect them as equal to as they respect males and females?
Ma'am, with respect, I would say we cannot wait to change the mindset of that mindset, but suppose we can initiate in schools to give the to provide them with education regarding the transgender act and all, so that uh, the students, those who have a transgender community, they don't face the bullying which they are facing in schools or colleges. And also, like
Is there an
You're not audible,
network
Jia.
issue? Maybe.
Arihant, are you there? You can also answer the question.
Uh, and from my point, I will suggest that changing the mindset is not our scope. What we can do, we can adopt certain changes or implement certain changes which can create a sense that if we violate the rights of the transgender, there is a stronger penalty. As in our the Transgender Persons Act, which I have just talked about in my presentation also, we have seen there that there is no statutory stronger penalties which is imposed for non-compliance, and the complaint mechanism or the non-compliance mechanism are truly weak and outdated. For example, under the Transgender Persons Act 2019, there under Section 11 it says that for every establishment there will be a complaint officer to whom we can register the complaints and grievances. But that procedure is very outdated. And another thing is there, if for the non-compliance or any kind of violation, there are no stricter penalties, either monetary or I will say.
But Arihant, don't you think we have penalty for a lot of things as well? For example, if you don't follow the traffic rules, you will have penalty, right? But people
Yes,
are still not following the rules. What about that? Penalty is not an easy way to tell people to accept them.
ma'am, but it can instill a mindset that if we does something wrong, then a punishment or a I will say that they will face they have to face certain serious consequences of that, and that
Okay.
will also help that will also
Ma'am,
help to
can
reduce
I
the crime.
answer to this?
No, it's okay. It's okay. We have understood what you want to say. Okay.
Should I call the next one,
Yeah,
sir?
and it's the last one.
Yeah, correct, correct.
Yeah.
Neha Gehlot, are you there? Anshuman Sharma and Neha
Yes, ma'am.
Gehlot.
Only
Here.
one. I
Okay,
think
are you
Neha will do the presentation, right?
Yes, sir.
Okay. Please go
okay?
ahead.
Are you ready with your PPT?
Yes, ma'am. Shall I share my screen?
Yeah.
Yes.
Okay. Um, is my PPT visible?
Yes, ma'am, it's visible.
Okay. Good evening to the esteemed. I think it's not yet evening. So good afternoon to the esteemed chair and my fellow participants. Today, I, Neha Gehlot, would be discussing on the paper Environmental Constitutionalism in the Age of Climate Crisis, Challenges of Justice and Enforcement. So first we will proceed with research problem. Just a second, it is creating a bit hindrance. Yes. So environmental constitutionalism recognizes the right to a clean and healthy environment, yet a gap persists between constitutional guarantees and their effective implementation amid the climate crisis. Judicial mechanisms, they remain slow, they remain limited in addressing complex and long-term climate challenges. So this raises a question whether existing frameworks can ensure timely and equitable climate justice or require reform. So now I'll proceed with the another slide of mine. Climate change is the rapid warming of Earth caused by human activities, which traps the heat in the atmosphere. It is a critical issue because it triggers extreme weather, rising sea levels, and food shortages, threatening both our natural world and our way of life. In defending environmental rights, courts play a crucial role, but disputes pertaining to climate change are time consuming. So, this paper uses a legal and ethical framework to critically analyze the expanding role of ADR in managing the global climate crisis. It examines the conflict between the rigid, slow moving nature of traditional litigation, raising the question of whether adversarial court systems are even capable of delivering the rapid green justice the planet needs. So, I'll move to the next slide. In recent years, global temperatures have risen more than 1.2 pre-industrial levels, 2025 being the hottest years on record in 2026 is predicted to continue to reach highs close to a 1.5 degrees Celsius overshoot. Greenland lost 279 billion tons of ice annually. Antarctica lost 148 billion tons between 1993 and 2019. Since 1969, the temperature of the oceans up 100 meters has increased by 0.33 degrees Celsius. There are efforts to limit global warming and strengthen climate resistance, but not so much useful. And failing to reach climate targets also raises issues of equity, issues of justice, as vulnerable populations are frequently the most impacted, even though they contribute least to the emissions. Floods, droughts, heat waves, they pose a serious threat to the vulnerable communities in low income countries, destroying homes, crops, livelihoods, driving millions of people into poverty and food security. Climate justice acknowledges that while making the least contribution to the causes of climate change, vulnerable and underprivileged populations bear a disproportionate share of its effects. Climate change is increasingly linked with human rights violations such as right to life, right to health, and right to livelihood. There was this case, Urgenda Foundation versus State of Netherlands, where the court held that governments have a duty to reduce greenhouse gas emissions to protect human rights. And in order to alleviate environmental injustice and safeguard vulnerable populations, judicial institutions are becoming more and more important. Courts are now crucial venues for upholding environmental commitments as climate change brings up difficult issues of responsibility and human rights. We can see the contributors are, we can see this data. USA is the 11% contributor, India is 7.5% contributor, EU is 6% contributor, Russia is 5% contributors, China is 30% contributors. So together they make up to 60% in comprehension. So by this data, we can infer everybody must have the responsibility to bear the responsibility to be liable, but not equally. They should not be equally liable. Everybody can be liable, but not equally liable. So, courts are now crucial venues for upholding environmental commitments as climate change brings up difficult issues of responsibilities and human rights. As a result, investigating alternative dispute resolution techniques become essential as quicker and more adaptable method. So, the absence of dedicated agency, ambiguous dispute resolution procedures have contributed to the poor implementation of international environmental law. ADR techniques, when we talk about ADR techniques and when we talk about courts, there are a lot of backlog of cases. We can see subordinate courts with 83% backlogs, high courts with 14% backlogs, and Supreme Court with 1.7% with backlogs. And when we have these many backlog of cases and we will implement another environmental cases into these, which will hinder our safety, our right to livelihood, that would also keep on lingering for years and years, diminishing our right to livelihood. So, ADR techniques are currently encouraged by many treaties for quicker settlement in order to handle multi party disputes. The Permanent Court of Arbitration established the PCA optional rules for arbitration of disputes relating to this natural resources and the environment. And there was this person, Richard the Builder, he defined it as an agreement between states over human caused environmental changes, which limited it mainly to interstate conflicts. So,
You
when we
have
can
just
see,
1 minute to go.
okay, I'll see, as we can see, there is a lot of success rates of ADR, 70%, 30%. It was the study of US and the other side is the study of South Korea. And then important case laws, agenda I mentioned earlier, Leg Hari versus Pakistan, Held versus Montana, and Ranjit Singh versus Union of India, they all talked about climate protection, which is inferred in Article 21. So, at last, I would conclude that ADR is a better option if we talk about climate changes. And as climate change is a major global challenge, we should opt for ADR. And at last, I would like to mention that as a convener of Unnat Bharat Abhiyan, I organized this uh, cleanliness drive on 23rd March, and with which we went to a village in New Delhi only, to Badusarai. I, with my around 37 to 38 volunteers, we can see here, I went to that village. We organized a cleanliness drive just to implement this at a grassroots level. With this, I conclude my presentation. Thank you all.
Your time is up, ma'am.
Okay, so the question is, just first confirm us whether you are using these three things or not. Do you have a car or a motorbike vehicle?
I have a scooty, sir.
Okay. Do you have an AC in your room?
Yes.
Okay. Since you are talking about the environmental concerns, obviously not only you, even I also use AC. We have cars. Many the large chunk of the population uses it. How do you think that although we people are talking about these concerns, but we are actually kind of taking certain kind of we are doing certain kind of activities which are anti-environmental. So how what kind of actions you would like to take to curb that issue or the kind of pollution that are being created by as we are using ACs and cars. And obviously it's impractical to say that we will not use it, we have to use it. But what other initiatives that we should take apart from afforestation?
Uh, okay, so as I mentioned, I use scooty while going to my college, and instead of using every vehicle of the house, we can just use the carpooling method, which I personally follow. I carpool with one of a friend of mine, so we three of us go together sometimes, and sometimes I with my other colleague go. So
No, i'm not
individually.
i'm not talking about you as you in particular. I'm talking about in the population way. Consider the collective initiative that should be taken to curb that thing.
Then I think the odd and even system that our government implements is a good one, and it should be implemented further because during COVID, when it was the actual odd and even system, we usually saw at that time that there were better AQI at that time, and whenever government implements this odd and even system, we usually get to see that we have better AQI. So for vehicles, we can do this, and
Can you just repeat what you have said? We didn't get you.
this odd and even numbering of the car. That this particular day the odd number cars will be taken out, and that particular day the even number of cars will be taken out.
Do you think it's sustainable?
If implemented seriously, and
No,
the
just see it.
battery vehicles.
Just see it from a very reasonable point. Okay, you may have a car. Okay, which is having an odd plate number. Now you are in emergency, but you have created that law that you can't go out. Then what next? So you are saying that I don't see this very sustainable. What other kind of mechanisms you would like to bring?
I would go for this battery vehicles then, as far as I believe.
So do you think? Okay, so for that we need to have a good charging systems, right?
Yes.
Okay, okay, ma'am. Thank you, ma'am. Okay,
Thank you. Thank
so
you
we
all.
will take 5 minutes break. Okay,